Thank you, Ken, and thank you to the task force and the discussions that we've had today. I advocate for an affidavit that would be provided to an individual before any proceedings can begin. We've seen that type of situation in other states. I also suggest that there be an alternative to probate court capacity and guardianship within a guardian ad litem type of model. I would recommend that the issue is not a probate issue and should be referred to the public defender's office so there is no conflict of interest. These monies cannot continue to come from a hardworking family, a firefighter, a nurse that worked their whole life. And as everybody has CMC hearings and regular hearings and ETGs and guardians, and there's no foundation to throw out the advance directives, all of this money is spent and wasted from the ward. And Florida statute says it's all about what's in the ward's best interest. But we can change these statutes and laws, but if we don't follow them and pay attention to those basic premises, where are we? I am working on an affidavit and language for that. I've attached it to the task force for review, but I'll read some of the high points. The guardian ad litem or advocate for potential alleged incapacitated person. The goal is to offer the individual, family, and the court an option before any proceedings begin. The advocate would meet with the individual and review and assess the situation. We would contact next of kin and gather documents, including DPOA, healthcare surrogate, will, trusts, and all advance directives. If they have a family member that takes care of them, and we advocate for their rights and their advance directives. If they don't have proper documents, we work with them to get the documents that will assist them. We make sure if the person needs ADA accommodations or language assistance that we've talked about today, we would do that before any other proceedings. They would decide if they would like their information to be public or private, and if any proceedings would remain open versus closed. Again, Florida statute says that that's the ward's decision, not the ETG, not the guardian, not the court-appointed attorney, and not the judge. But we ignore that every single day. We would explain the statute that would have the right for their own counsel and the right to substitute if the court gives them an attorney. But again, that's Florida statute. I'm a perfect example. We didn't follow that statute either. We discuss with the person and their family if they need any supportive care plan in place in order to have their rights maintained and their freedoms to be
30
respected.
seconds.
The goal would be to put the ADLs and the financial support in place to respect the advance directives and DPOA and HCS in place. They would put their goals in writing and sign and date the affidavit, and we would have it notarized. In the event the court were to ensue with a case, the guardian ad litem would attend every single conference
10 seconds.
with the individual and advocate for them. We continue to outline best practices as it relates to the process. Thank you very much.
Thank you, Ms. Melendy. We appreciate your attendance at these and your comments.